government. Remember, the United States government. The term United States government, you should look up 28302 parenthesis 15 parenthesis subsection A. So it should be 15A. So it should be 28302 15A. And you'll find that the definition of corporation of the United States government. I also, if you're in the state of California, look up Penal Code 7, Section 19, which defines a state, which is part of the United States, which is part of a territory, which makes them foreign. You have to remember that these people aren't actually here to help you. They're here to make sure you stay in continuous debt. Now, I looked up the 63rd Congress, the second session, chapters 4 through 6 on 1913. This basically talks about who is running the shit. And I can't stress this enough, but the banking industry runs everything. They're running the shit, not Washington, D.C. Don't let D.C. freaking lie. And they're not in charge. They have no more authority than you and I. I also ask people that if they are interested to look up H.R. 51 of the 116th Congress. This is Washington, D.C.'s asking to be administered into the Union, which means that they're not even part of the Union. So how can they act in any capacity for the whole state? That's incorrect. Now, I want to read sections Section H.R. 13995, reading part. The U.S. Secretary of Treasury receives no compensation for his representation of the United States. Gold and silver were such powerful tools during the United States of America that founding fathers declared gold and silver can be money in America. Since gold and silver were heavy and inconvenient for a lot of transactions, they were stored in banks and claimed in checks as money substitutes. People traded their coupons as money or currency. Currency is not money, but money is substituted. Redeemable currency must be a promise to pay equivalent to gold or silver. Federal Reserve notes, FRNs, remember that if there is nothing backing that is an unprotected debt. They can't have an unprotected debt. That's unlawful. These individuals said that also in this speech. This is from James Trufant. This is his actual speech. I want to show you here. This is from 1933. For all those who are watching, that's his speech about gold, the gold and silver, and the gold standard, and that the fact that we're not backed. Now, we are not backed by the gold standard. We have no way to pay those FRNs, those Federal Reserve notes. Remember that here's the executive order that I was talking about, the bankruptcy and the selling of our industries. Our infrastructure has been bought and sold. We are already bankrupt. We have no money. I wanted to show this because this is from the American Presidency Project. I want to thank them also for all the research and information that they have provided, and the police continue to provide such information. This is from 1933. This is from Teddy Roosevelt. Franklin D. Roosevelt. Different Roosevelt. I think they called him Teddy, though. Yeah, so he made us bankrupt. He put us on the gold standard. He took us off the gold standard. He exported all gold bullion, gold certificates, and replaced it with the unlawful FRN dollar note. Now, most people are like, well, at this point, you're probably thinking, well, I can't pay off for the gold standard. I have unsecured debt. What can I do? Well, if you are looking for a solution, you have to remember that they did give us a way to discharge these debts, to make the account go to zero. I would recommend people read 26 CFR 601.204, changes of accounts, periods, and methods of accounting. Also, Part 1, 263A, 446, 4471, and 4478. The revenue precedes exclusive power which the taxpayer obtains for the commission under 446E of the Internal Revenue Codes, exchanging one method of royalties described in 1.263A, 1E32, that's the two I's, U2, like the number, of the income tax regulation, changing the accounts method for the sale-based venues chargebacks. So this is talking about chargebacks. You can charge back. Remember, you're the creditor. Let's say a judge files something on your behalf. He files a bond, right? He is a trustee. He is the individual who is holding the account in trust. Now, I want to show you this document because it's a lot of information. Again, anybody who wishes to acquire this information, feel free to send an email to me, and I'll gladly email you a PDF version of this for you to review for yourself. And you can see that taxes are unlawful. Now, we are able to discharge the efficiencies of our debt to zero. The trustee has a duty to do so. Remember, when you are going into such things as courts, or you're using these utensils, negotiable instruments are being used upon you, you have the right as the beneficiary to the estate to have those efficiencies, because the duty of a public official is to discharge all debt to zero. And you have to remember that these banks they were reopened in 1933. There's a company in the state of California called Conica, CONICA, legal the services. I think this company has financial interests in the banking industry. It's also connected to the local state bar. So the state bar and the banking industry are working together hand in hand like this, right? And creating financial interest. Now, remember, under the CFRs 2727.11 that when you are committing commercial acts, you are committing commercial acts of business. Now, remember, when you go into any sort of business with the state, you are considered a minor in the eyes of the law, because you are entering into an account of commercial booking into your public, with the public official. And remember that the custodian has to, the holder, the beneficiary, that's you're the beneficiary equitable title holder, has a duty to tell that individual to make any accounts of the debt go to zero. Now, I want to show you this because according to the law, when you become 18, you are actually able to, let me start by this. When you are first born, you are given a Social Security card along with your birth certificate. Now, let's say that you didn't get one. Well, you can acquire one. I can go in without the baby and say, well, I had a baby. here's the birth certificate, here's the immune shots, and here's the doctor's signature. And I'm the father, and I need a birth certificate. Now, the birth certificate is issued. Now, according to the law, when you reach the age of majority under 31 CFR, remember that's the Council of Foreign Relations. Remember, we're all under the United Nations when we became part of the United Nations in 1945, when we had that treaty with that unlawful treaty with the United Nations. Now, I want to show you this. This is CFR 31 3.27. This talks about your minor account. So you are a minor even though you have reached the age of majority. In the state of California, the age of majority is somebody who has reached the age of 18. Please look up the definition. I'm not sure if it varies from state to state, but according to the IRS, you are the liable one when you sign your name as you, and you not as the beneficiary. Now, I want to bring your attention, because I went to the IRS manual, and I found 21.7.13.3.2.2. This is from April 23rd, 2019. This is the tax identification number form SS4, line 7 or B9. Now, this talks about the corporation, the term corporation. Under that term, remember, you're held liable as a taxpayer under that SSN, the employee number. You're not the employee, you're the beneficiary. It actually says that line B7, SSN or TN or EN of the principal officer, general partner, member, or owner, also known as the responsible party of line 7. Entity type, corporation, partnership, UBO, UBT, PTO, business, trust, or LLC. Now, exceptions: SS4 applications mailed and faxed on the March 19th subsequently cannot be listed as an entity. EIN actually says this, that the EIN is actually cannot be as the responsible party. The responsible party must be an individual with a valid SSN/TN. Line 9, SSN/TN owner. Now it goes into it and talks about with a valid SSN/TN. Line 9, SSI ITIN of the descendant. Remember, the middle name is a descendant name. That's the descendant of who you're from. Line 9, SSN, TN or EIN of the grantor, owner, or custodian of trust. Government. Line 7B, SSIN/INTIN or EIN of the agency or representation of government. Now, I want to show you this. You can see IRS. This is printed from the IRS. And it talks about the grantor, owner, or custodian may establish Amish or Mennonite as for a reason to supply, not to supply for SSN ITN, an infant or the descendant of an estate grantor, custodian, trust, or trust guardianship. I also want to show you another. I found talks about the 21.13.7.2.3.2.2. It says an infant or descendant of a grantor or custodian of trust or receiver of the guardianship has yet to receive an SSN. An infant is a descendant.
You ready?
And so when you are holding these, when you are held at a court proceeding, or you are held at some type of by some state agency, you have to file a IRS Form 56. You have to file a request for tax information, an 8822. You have to ask for these informations, otherwise these agencies like the IRS don't know. See, the courts have to, by law, file under the taxes, but they don't because you don't file your 56. You don't file as the attorney. Once you're able to handle your own affairs, you'll be able to do things like this. Now, remember, you can discharge the debt. You can stop the IRS from harassing you too. You file a 12277 form, and this stops liens. This stops, like, let's say the IRS puts a lien on your house or your bank account. You can actually stop them through the Fresh Start Initiative in that IRS Form 12277. Now, I've learned all this through my long, extensive amounts of research, and this is just some of the stuff I've learned for the IRS. There is a lot more, but I'm already at almost 50 minutes here. I've been going on here about the IRS and talking about the IRS. Now I want to talk about your credit report because this is important, because they always talk about how to fix your credit in 90 days. People need to learn about the Fair Debts and Reporting Practices Act, Statute 609, Fair Debts and Collections Practices Act. Now, most people say, don't do this. It'll affect you and affect your credit. Well, everything you do affects your credit. When you apply for a credit card and you get denied, that affects your credit. When you don't pay a loan down on your car, that affects your credit. In other words, what I'm going to teach you today is how to list every account on your report and how to make sure that those contracts have to be shown in order for them to pay. They can't just come and collect. They can't just take your money and say, well, that's it. They have certain laws that they have to follow under the Fair Debts and Collection Practices Act. I also recommend that if you're going to do the request for validation under the Fair Debts and Collection Practices Act, that you scan a number of your Social Security number, your TIN, and your license, because that's going to go to TransUnion, Equifax, Experian, and TransUnion. These people already have your information like that, so it doesn't really matter. These are the people who handle all the credits under the Fair Debts and Collections Practices Act 1562. 1692, sections 809B. So that's 15 U.S.C. 1692G, sections 809B. You have the right to claim a dispute and request for validation. Remember, you're requesting for validation, not verification. I want to show you a sample letter. Things you want to request are products you're being charged for, the calculations for the drive balance, any copies of any papers you agreed of what they said you owed. That's the original consumer contract, which is very, very important under Statute 609. They have to show you the original consumer contract. They cannot just say, well, you owe me money and try to collect. Remember that they cannot increase the amount you owe. They cannot charge you any interest for the amount you owe. That is extremely unlawful under the Fair Debts and Collection Practices Act. There's ways to write a drop dead letter. So basically say, don't call my phone, harass me in any way. You will have to write me by written letter. You have to ask them to provide you a copy of any judgment if applicable. Let's say you have a judgment against you for $50,000, right? They get a lien on you. And they have to show that even though they got the judgment, you can still statute 609 and request for the Fair Debt and Collection Practices Act for them to show